Welcome to the finale of Piercing the Corporate Veil, Lessons from the Docket. I'm Professor Seth C. Oranburg, and across episodes 1 through 7, together we explored the essential doctrines, landmark cases, and modern evolutions of veil piercing. We went from Walkovszky v. Carlton and Becker v. Interstate Properties, all the way to cases like Doe v. Uber Technologies. Now, in episode 8, we synthesize these lessons and focus on practical prevention strategies for business owners, their lawyers, and law students who are trying to wrap their heads around actionable insights for piercing the corporate veil. So, what have we learned? Veil piercing doctrine balances the benefits of limited liability, which encourages investment and innovation, with the need for accountability when structures are abused. Key themes have emerged across our series. Limited liability is not absolute. As we saw in Walkovszky and Becker and in Best Foods, courts may pierce when entities are undercapitalized or used to externalize foreseeable harms and commit some kind of wrongdoing. The tests are flexible, not mechanical. The ideas are unity of interest and injustice, but these adapt across forms, especially as we saw the LLC form, and in new contexts like reverse piercing, horizontal piercing, and parent-subsidiary piercing, with factors like commingling and domination being reoccurring themes, especially in modern contexts, like Uber's case. The doctrines evolve as business evolves. We've gone from traditional taxis to gig platforms, and piercing addresses new integrations. Because context matters, piercing favors involuntary creditors over voluntary ones, and it favors public policy concerns versus private concerns. But again, it's a very general doctrine, and there isn't one straightforward way to totally understand it. The general rule is that form follows substance. Genuine separateness, separate records, adequate funding, independent operations is paramount. So you'll be treated as if you have a separate entity if you act like you have one. As I said in the first episode, if you respect the law will respect you. And these principles ensure fairness as they're evolving to meet challenges like digital control and global chains. So, what could you do if you were a business owner or an attorney for a business to safeguard your company and to help the limited liability shield stay intact? Well, there are some very clear takeaways that I can offer here. 1, maintain financial boundaries. Use a separate bank account, use a separate bank account, use a separate bank account. Document any inter-entity transactions meticulously. You must avoid commingling assets. Second would be to ensure adequate capitalization. Now, how much capitalization is adequate can be difficult, but if you're in an industry which is likely to cause harm, having insurance and reserves are important. Third is observe formalities rigorously, especially if you are a corporation. Hold meetings, keep minutes, and follow all the rules. But even flexible entities like LLCs and even single-member LLCs should mirror the rules for corporations to the extent that it's reasonable, because you want to show that you've been treating this like a separate entity, because if you treat your business like a separate entity, the law will too. Fourth is promote independent governance. Limit overlapping roles between corporate groups and parent and subsidiaries. You have to ensure that there are arm's length dealings, especially in context where there is a commonality of goals or purpose. 5 is craft strong agreements, particularly in LLCs. You really need a good operating agreement to prove separateness, and not just having the agreement, but following it. 6, limit operational control. Parents can oversee without micromanaging. In fact, they must not micromanage. Direct involvement triggers liability. And document high-level guidance only. Show that you're giving independence to your subsidiary. 7, secure comprehensive insurance. This relates to undercapitalization, but the existence of insurance can show that you cover foreseeable losses, which shows that you are respecting the corporate form and reduces inequity arguments. And 8, conduct regular reviews. Audit structures annually for compliance and adapt to evolutions. Try to follow the law, because if you're in a special area, like the gig economy, cases like Doe v. Uber are going to importantly change how you maintain limited liability. In addition to these positive things, let's talk about some reoccurring traps to avoid. One is single member LLCs. There's a higher scrutiny for unity, especially because many single member LLCs are formed with basically legal Zoom documents, and they're not treated with any separation. And when a person doesn't have a separate bank account and doesn't treat the business separately, the law won't respect it as a separate entity either. Two regards series LLCs and other affiliated entities. Again, blurred lines invite horizontal piercing, so you have to ensure true isolation. Even if you benefit from series LLC law and don't have to create a new entity every time you have a new real estate project, you should have separate bank accounts, you should have separate management, you should have separate decision making for each of those series. Third, in cases with regulatory oversight, note that environmental or labor law can give basis for what's effectively piercing, even if there wouldn't be piercing under corporate governance. 5, fraudulent intent is a basic guarantee of piercing. And if you act fraudulently, you expose yourself to criminal exposure. You can't just use a corporate form to commit fraud. The law can't be used to commit an injustice. This one should be obvious. And 6, digital integrations create new frontiers. Algorithmic control and gig models could mimic domination. And as artificial intelligence enters the scene, we have new questions which should be exciting but challenging. Looking ahead, veil piercing will continue to adapt as artificial intelligence, blockchain, cross border applications, the gig economy, and all sorts of new forms continue to develop and push on our understanding of business entities. So it's really an area to stay vigilant. And just remember, ethical practices is your guide, informed structuring is your best defense. This series has equipped you to analyze, apply, and avoid veil piercing pitfalls. Remember, respect boundaries, prioritize substance, and act fairly. Some of this is common sense. Thank you for joining me on this journey through the docket. I'm Professor Seth C. Oranburg, and I hope that this has helped you stay organized.